the debate. I'm going to introduce very briefly, trying to be as neutral as possible, just what the notwithstanding clause is and the context for this. Then introduce the resolution and the debaters and the format, and we'll proceed. Canada's notwithstanding clause is contained in section 33 of the Charter of Rights and Freedoms. It's a clause that was pursued by some provincial premiers as part of the Charter during the negotiations leading up to 1982, and without which the Charter would not have been adopted on the position of those premiers. It permits the federal parliament or a provincial legislature to enact laws notwithstanding sections 2 or 7 through 15 of the Charter, meaning that a court cannot use Canada's constitutional clauses on fundamental freedoms, criminal justice issues, or non-discrimination to strike down the law that's enacted notwithstanding those clauses. There's a 5-year time limit on each use of this clause, though it may be renewed. There have been a number of uses of this clause by provincial governments over time, never by the federal government, although some have argued very strongly against the clause, and some feel that a stigma attaches to its use. A court ruling in Saskatchewan in early 2017 in the Good Spirit School Division case saw a Court of Queen's Bench rule that it was impermissible on religious freedom grounds and non-discrimination grounds for Catholic schools in Saskatchewan to receive provincial funding for non-Catholic students. And this would have had the effect of requiring potentially thousands of students to change schools if upheld on appeal. The Premier ended up announcing that Saskatchewan would use the notwithstanding clause to provide for stability for children and parents and to defend school choice even prior to an appeal. A bill was introduced to that effect in the Saskatchewan legislature this past fall. Today we have two debaters who will wrestle with the issues of the use of the notwithstanding clause. In the wake of Saskatchewan's choice to use it, some scholars immediately reacted, suggesting the inappropriateness of using it, and others defended it. So we have a highly topical issue. And that's framed as be it resolved that the government of Saskatchewan was justified in invoking the Section 33 clause in the Good Spirit School Division decision, or it might be thought of more simply in terms of that Section 33 protects democracy rather than being a disaster. And they may speak in more general terms, more so than about the case. On the pro side, in support of the notwithstanding clause, we have Jeff Sigalet. I should skip where he's from, having heard that this is his first trip to Saskatoon, but he's from Edmonton. He completed his BA in Political Science and Philosophy at the University of Alberta, his MA from McGill on Political Theory, and then he pursued his PhD studies at Princeton University on Dialogue and Judicial Review. I had the great opportunity of meeting him there while I was a visitor there. He's currently a fellow at Stanford University's Constitutional Law Center and a lecturer at Stanford Law School, where he teaches conflict of laws at present. He's co-editing a volume on constitutional dialogue with Cambridge University Press, and he's organizing a conference at Stanford this June that will presumably lead to another shortly. He's also contributed op-eds and publicly accessible pieces to such venues as the National Post and Policy Options. On the contra side, Jason MacLean has been on the University of Saskatchewan faculty since 2017, having moved here from a faculty post at the Boralaskan Faculty of Law at Lakehead University. He completed the combined common law civil law degree at McGill, and he's currently completing his PhD degree from Alberta. He spent a number of years in practice in the international law, clerked for Madam Justice Deschamps at the Supreme Court of Canada, and worked in a legal career as a corporate and commercial litigator with Sherman and Sterling on Wall Street in New York, and Osler's on Bay Street in Toronto. He's appeared at all levels of court in Ontario and the Supreme Court of Canada, as well as at a number of courts in New York State. Today, he actively works in climate change and sustainability as a very prolific scholar. He's a member of a board of directors of an environmental law related litigation NGO, and he's a public intellectual who contributes op-eds and publicly accessible pieces to such venues as the Globe and Mail, Toronto Star, MacLean's, and Policy Options. So we have two very distinguished debaters here. We look forward to their discussion. The format is that there will be an opening presentation by each, for which they'll have up to 10 minutes, although they need not take that full time. Then there will be a second speech by each to give them a chance to reply to things that have come up already for up to 3 minutes. I'll ask some rapid fire questions at that point, to which they'll each have 90 seconds to respond on each. We'll then have a chance for audience questions. I've prepared my questions, and when I write them down, they conclude with a punctuation mark called a question mark. If you think of the question that you're going to ask and imagine it in written form, it should have a similar punctuation mark. So short questions to which they'll have the chance to reply. And then there will be a chance for closing statements. They'll be in the opposite order, the opponent first and then the proponent. I asked them not to introduce brand new arguments at that point, but only be responding to things that have been part of the debate. Through the debate, I will offer time signals with the number of fingers corresponding to the number of minutes, half, and at time there will be a bang, and if there's much overtime, there would be more bang. So we will proceed on that basis, and I certainly look forward to the discussion and invite Jeff Sigalet to propose the motion.
So thank you, Dwight, for inviting me here. Thank you, Professor MacLean, for debating me. And thank you, Joanna, for organizing this, the Writing Society, for flying me out to beautiful Saskatoon, sunny Saskatoon. It's particularly delightful to be discussing this topic, the notwithstanding clause, in Saskatchewan, given the rich history of this province has had, and its politicians and scholars and judges have had in the development of Canada's Bill of Rights culture. I think that it's very interesting to note that as Canada's moved away from a more traditional Westminster style system towards having an entrenched constitution, a patriotic constitution, and having more American style rights restrictions on what our legislatures can do. Saskatchewan's played a great role in that. The idea of a notwithstanding clause is not something that emerged with the Charter. It actually emerged with the Canadian Bill of Rights Act, and is a unique constitutional instrument in comparative constitutionalism. There was no other non-obstant provisions in any world's constitution before the Canadian Bill of Rights Act that I'm aware of. And that Bill of Rights Act was enacted by a Saskatchewan Prime Minister, John Diefenbaker, and was the result of agitation and a lot of interesting scholarship produced by Walter Tarnopolsky, he lectured here, didn't he? Of course, the notwithstanding clause, the subject of tonight's debate, was the result of the two Prairie premiers, Alan Blake, the NDP premier from Saskatchewan, and Peter Lougheed, the Conservative premier of Alberta at the time, asking for the notwithstanding clause, or requiring something in the form of the notwithstanding clause as a condition for the patriation of the Constitution. Albertans like to claim that they're responsible for it, and Peter Lougheed has a story saying that his advisor Merv Leach is really the brains behind the notwithstanding clause. But I think that Saskatchewan has a very good claim to considering it its own an instrument produced by its own great minds and politicians. So today I'm going to speak on behalf of that instrument and the use of that instrument in the case of GSSD versus and CTD. Americans sometimes say versus for cases, and I've started to take that up, and it's a bad habit. So I'm going to speak on behalf of using notwithstanding clause in this case, and using a notwithstanding clause generally. I think that it's important when we consider the question that we're debating today to I should get going. To distinguish between two questions. First, I talk too much. First, we can divide my view of the resolution before us today into two parts. First, can the notwithstanding clause be used generally? And if so, how? Second, should it be used in this case, in this particular case? The case, as Dwight mentioned, involves invalidating funding for non-Catholics, public funding for non-Catholics by the Saskatchewan government and Catholic schools as a violation of the charter rights, freedom of religion, and equality. My view is that the notwithstanding clause is, of course, good law still. There's no convention against using it. Even if there was a convention against using it, that convention has been disrupted by its use now. I think that there's a lot of interesting things to be said about the nature of constitutional conventions and Commonwealth constitutionalism, but I don't feel like there's any kind of convention against using the notwithstanding clause that might be similar to, let's say, the federal power of disallowance, which arguably there is a convention against using. So I think that legally there's no case against using the notwithstanding clause as a matter of law. Now there's a question of under what conditions should we use it, and how should we think about its use if it can be used. I think that it can be used, and it should be used, not as a matter of just indiscriminately overriding rights. This is the first great objection to using it. Just that people say, look, on its face, it says that a law is enacted notwithstanding such and such rights. This means that the legislature's overriding the rights. Well, I think that is indeed a worry, that the clause could be used to do that. It can be used to override rights just overall. But I think that the uses of the language of the clause doesn't necessarily mean it will be used in that fashion. And I think that if we get into it, we don't have time to get into it. But if we get into the history of what the clause was initially proposed for, the framers who proposed it thought they were getting in having it included in the charter. And if we just note the simple fact that it's in the charter, it's in this list of rights we have, this right to override rights in certain circumstances and only certain rights, and to have that override expire and be forcibly renewed every 5 years, to me, it's hard to unpack a reading of what that all means into 2 minutes here. But my view is that it should be used for something along the lines of what James Madison in Federalist 37 called constitutional liquidation, which liquidation doesn't mean like a fire sale where you sell off the family furniture or something like that. And at that time, it meant making something clear, making rights that were indeterminate clear. I think that we can all agree that the abstract formulation of the charter rights and freedoms are what they would come to mean in Canadian constitutionalism wasn't exactly clear when they were enacted. Now our courts have over time helped clarify their meaning in different circumstances as they relate to different kinds of laws that our federal and provincial legislatures have enacted. But I think that what the notwithstanding clause stands for is that it wasn't just for the courts to make those rights clear, those abstract formulations. There was also legislative responsibility for enacting statutes that elaborated what those rights would come to mean. And that's why we have a form of pre-enacted rights review, where the Minister of Justice has to now she, according to the new amendment to the Department of Justice Act, she has to give charter statements explaining the compatibility of statutes with the charter. And that comes from the fact that statutes help elaborate what rights mean. This is a fundamental, I think this is an indisputable fact. So when should the charter, so how should we think about the notwithstanding clause in that context? Well, it expires, so the use of it doesn't mean the legislature, to me, doesn't mean the legislature's word once it's been used. That's it, that's the meaning of the right. It has to continually be reaffirmed either continually reaffirmed in the face of judicial intransigence by the legislature, or eventually the judiciary has to come to be open or maybe compromised in some way with the understanding of rights elaborated in the use of the notwithstanding provisions. And in that way, the notwithstanding clause stands for sharing the interpretive role over rights with the courts. Now, in the case of GSSD, so I think that if you agree with that use of the notwithstanding clause, it can be used to help enunciate, to help clarify rights that are indeterminate. If you agree to that, and there's many arguments that Jason will go over for why that might not be the case, then I think that it should be clear that the GSSD decision that we're talking about today constitutes a case where there's some serious reasonable disagreement to be had about what the meaning of our charter rights to religious freedom and equality, how those rights relate to funding non-Catholic students at Catholic schools. To me, it is not simply, to me, the question in the case was not, do our constitutional provisions for protecting denominational schools violate those rights? That was never the question. Although the court says axiomatically they violate those rights, which seems to me a problematic thing to say. But it seems to me that the question is, can there be reasonable disagreement about the compatibility of funding non-Catholic students at Catholic schools with the right to religious freedom and the right to equality? And it seems to me, yes. On one view of how those rights relate to funding non-Catholic students at Catholic schools, on one reading of that, you have the idea that this is encouraging and resulting in the state openly funding the propagation of the Catholic religion, and therefore unequally privileging it over other religions. Now, to me, that is one possible way of reading how those rights relate to this, to the statutes that are funding non-Catholic students. But that's just one way of looking at it. And the result of that will be quite extreme. It will result in the legislature having to actually formulate, having to develop tests for who's Catholic enough, who's not Catholic, or either doing that and sending a bunch of non-Catholic students out into the cold and forcing them to pay to go to Catholic schools, or funding every religion in this province equally, which is not, I don't think, feasible. I think we'll end up, if we go that route, we'll actually end up with no funding. The alternative understanding, and I'm just going to make a pitch for this really quickly, there's reasonable disagreement between that view and the view, simply put, that funding, giving parents the ability to send their students to either Catholic schools or non-Catholic schools that's the definition of neutrality. That there are Catholic schools, those are constitutionally protected, and parents have a choice to send their students to those schools or not. That's actually extending a freedom, the right to religious freedom, and extending equality more broadly. Anyways, that's my time.
Thank you. And we'll now have the opening speech by the opposition.
Thanks. And thanks, Joanna, for inviting me to be a part of this. I think this is my third Runnymede event, and I first met Dwight at an initial Runnymede brainstorming meeting where I was deemed a tolerant liberal, somebody who's willing to have debates with folks like Jeff.
God bless you.
So thankfully for this debate, we didn't have pre-debate discovery. Otherwise, Jeff would have already learned that I agree with him on some points, and he wouldn't have spent some of his allotted time on points that we agree with. So, first of all, there's no serious disagreement to be had that Section 33 remains, it's good law, it's in use, and it's there. And I'm not going to try and stake out the argument today that, as some legal scholars have, that it should be presumptively unavailable or not used. I accept as a general proposition that it can play a rights-enhancing role. The question, and I think this is where Jeff and I, we may agree in principle, and I think the disagreement will really crystallize in respect of a decision in this particular case. I think in principle, I agree with everything that Jeff said, that legislatures, just as much as courts, can play a meaningful, or as Professor Newman puts it, a coordinate role in rights interpretation, and can even play a rights enhancing role. I don't take any, I don't disagree with that, and as much as I love alliteration, like all academics do, I don't think the choice today is democracy or disaster. But the way Jeff framed the second part of the question, I think, is really helpful, which is, okay, if Section 33 is with us, and it is, and I actually think it ought to be, it's part and parcel of the Charter, that critics of Section 33 otherwise support and valorize. The question is how it should be used. And at its highest, in reading through the really interesting and rich history of debates about Section 33, to me, one of the most interesting defenses made in terms of Section 33 as playing the role that Jeff pointed out in a kind of a dialogue with courts in terms of figuring out what rights mean, and more specifically, not just what they mean, but how to properly limit them in particular contexts where there are competing interests at play. Courts have definitely developed an expertise in that regard, but courts aren't fallible. Right? Legislatures can play a meaningful role, but to me, the question of whether in any given case the use of Section 33 is going to be justified, and I mean that more in a political way than a legal way, is a question of process. It comes down to how the legislature invokes Section 33. And to me, the way in which a legislature invokes Section 33 has to be consistent with the very powers that it has that gives rise to it playing this meaningful role in the first place. And that is as a facilitator of reasoned public debate, discussion, and deliberation. Not unlike, in a way, what we're doing here today. So in that sense, to the extent that the legislature can play a role, and it doesn't have to be a formal role in terms of sitting in the legislature in session, but in using its resources to facilitate meaningful discussion that brings into light, into clear reality, into clear relief, the nature of the right at stake, its view of the nature of the right at stake, and how to balance that against competing interests is the critical question. In this case, I don't see evidence of the government, the provincial government here, exercising that comparative legislative advantage. So let me walk you through that. The decision, I agree, may be problematic in certain regards. I think with respect to the charter interpretation, and Jeff made reference to a claim made by the court that certain elements of funding would be axiomatically breach of the charter. I think that's likely a problematic statement as a matter of law. But the way in which the debate around this case is played out is really interesting in some ironic ways. One of the critiques that's leveled against those who argue in favor of courts having an exclusive role in making decisions about determining what the meaning of rights are and how to balance those rights is that that's an elitist argument. And it's contrary to parliamentary democracy and parliamentary sovereignty. But what's interesting in this case is that there are a lot of really, in preparing for this debate, there are a lot of really interesting and compelling statements made both in press and in academic scholarship and sort of in that area in between of public commentary by legal academics, expressing why this decision is problematic, why it fails to grapple with particular realities in Saskatchewan, Saskatchewan's history and Saskatchewan's current situation. What's interesting, however, is that the Saskatchewan provincial government hasn't made these arguments. In response to the decision, the government issued a very thin, and I wouldn't even say thinly reasoned, it just isn't reasoned, press release saying that it's going to invoke Section 33. Despite the fact that the decision had been stayed for a year by the court, so there was no immediate rush to do that. Chaos wasn't going to reign among parents, so the stability that the former premier promised was already in place at least for a year. So initially there was a declaration that 33 was going to be used. Why? On the basis of protecting school choice and providing stability. There was no definition or discussion of the meaning of the right. There was no definition or discussion of the competing public interests at play, the limits of public funding in in the realm of education, rural depopulation, a number of the issues that are at stake here. Now, a number of those issues have been raised in academic commentary, but not by the government itself. Then the government released further statements saying, well, now it's actually going to appeal. And it's released so many contradictory statements. It said, well, we don't necessarily disagree as a point of law with the court, but there are practical Saskatchewan reasons that lead us to disagree. But on the other hand, by reason of launching an appeal, they clearly do think that they have a legal argument. So there's a legal disagreement as well. There was no rush in this case to invoke Section 33 for the purpose of overriding this decision before the courts have had a chance to actually clarify what the definition of the right was. A more reasoned and deliberative approach to using Section 33 in this case would have been to stake out, first and foremost, the specific reasons for its disagreement with the trial court's judgment. Not just the result, and not just what some of the implications of the decision might have been, some of which weren't actually even squarely before the court. Then secondly, the province should have decided whether it was going to pursue an appeal because it thought it had a legal basis for overturning the decision, or if not, otherwise provide its interpretation and explain why it wouldn't be appropriate to seek out the opinion of the highest court in Saskatchewan before invoking Section 33. So ultimately, in my view, Section 33 and its legitimacy in our constitutional order depends not on just its formal existence and its formal use, but rather how it's actually used. In this case, I would argue that it's been used hastily. We might be able to, as my learned friend has done in one of his pieces, infer what the balance and the competing definition of the right at stake was in this case and what the government may be thinking. But I would prefer the government do that because the basis of the Section 33 power is the government's ability to do this, not for academics to bootstrap the reasoning of the government, which the government hasn't provided.
Okay, thank you. So Jeff now has a chance to offer a short second comment if he wishes to reply to anything or build any additional arguments. Up to 3 minutes.
With a great deal of that, I think that ultimately I would just agree with Professor MacLean that there was a paucity of reasoning about the justification for invoking Section 33 in Premier Wall's press release. It's still to be seen what exactly will go on in the legislature regarding the bill. If I'm not mistaken, the bill has been introduced and is in its first reading. So we'll see. Maybe the opposition will bring some things up for the government to justify what it's doing with the various notwithstanding provisions of the bill. So I would agree with Professor MacLean that there needs to be in order to legitimately use Section 33, it cannot just be a case where the government simply overrides our rights as Canadians. It has to do so, it has to use the clause to elaborate an alternative conception of rights. And in doing so, it might not do that in press releases. It might not, but I think it's important to note that it might not do that in its press release, especially if it's planning to appeal the decision at the same time it introduces it into a bill, a government bill. I would say that it's too soon. It's perhaps too soon to tell whether or not there's been an adequate justification. Perhaps Saskatchewan would benefit from, and using Section 33 would also benefit from something like the new federal practice with charter statements. Perhaps there should be, we should have a norm in our democracy where when legislatures want to invoke Section 33 or any legislation regarding charter rights, they are forced to elaborate how they conceive of the charter. In some sense, the problem of judicial review and its democratic credentials isn't necessarily about courts foisting themselves undemocratic in a counter-majoritarian way on us. It's often about our politicians not wanting to take responsibility for some of the hot-button issues that we face as they relate to charter rights, and letting the courts make those decisions, and then maybe decrying them publicly or whatever, but saying, oh, it's not in our hands, we don't have to interpret the Constitution. We should certainly demand justifications for the use of Section 33, but merely as a part of a broader demand on legislative responsibility for rights. So I agree with the thrust of Jason's comment, actually.
Okay, thank you. And we'll now turn to Jason, who has up to 3
Well,
minutes.
now I'm tempted to argue with myself. People came here for a fight, and I'm sure that we give them one. This is Saskatchewan, for God's sakes. What I do think, though, we do disagree on is the implication and the implication of Section 33 in this case. True. We shouldn't, and I don't want to be understood as saying that in a brief press release that the government should provide something analogous to juristic reasons for its decision. But it's been over a year. And so the initial reaction, and it was a quick reaction following the decision, was, we don't like this, this is contrary to school choice, this creates instability, notwithstanding, sorry, I couldn't help it, but I didn't want to use that word. Despite the fact that the court stayed its decision for a year, we're invoking Section 33. But then after that, and I've looked, I still haven't seen that reasoned discussion. I've seen Jeff's very thoughtful inference about what that balancing might be, that this decision, the decision made by the government, is the best way to balance the charter with the Section 93 of the Constitution Act protection for Catholic minority schools in the province as part of the Confederation bargain. But as brilliant as you are, I want more than your inference. I want evidence of the government's deliberation. I want to see evidence of an opportunity for meaningful public deliberation. Now, it's also not fair, I don't think, to say, well, you can't expect the government to provide reasons for its invocation of Section 33, because after all, it has to preserve its legal strategy for appeal. Well, it's not forced to do either of those things, and frankly, as a litigator, invoking Section 33 and then saying that you're going to appeal to the Saskatchewan Court of Appeal is a disastrous, to use the word of the board, legal strategy. It's a way of signaling to the court, I actually don't care what you think. We don't care what your reasons are. We don't care what your alternative interpretation of the rights would be. If we lose, we're just invoking Section 33. If we happen to win, well, great. That really isn't, to my mind, a good faith use of Section 33 or a proper way of engaging in a reasoned, coordinate dialogue between the legislature and the courts.
Okay, thank you. So we've had the opening comments from each and the second round of speeches. We're going to now turn to a brief question period, and I'll ask the first few questions and then give the audience an opportunity. I'm going to ask one question directed against each of you, so then giving you the first chance to respond to that and then the other, and then I'll ask a question that hopefully challenges both of you. So my first question will be directed to Jeff in the first instance as a challenge to the notwithstanding clause. Professor Ken Norman of this faculty has described using the notwithstanding clause prior to an appeal as putting the charter on ice, and has suggested that the Saskatchewan government should follow what he calls the normal judicial process and give the appellate court an opportunity to rule. How do you react to this argument that the government is in some way disrupting the normal process by using the notwithstanding clause in advance of an appeal?
That's a great question. I think it fits really nicely with my theory that using the notwithstanding clause doesn't signal this is the construction, this is the conception of rights we want, and we're going to get it no matter what. It has to be, the government's changed. The government will, whatever happens at the Court of Appeal, the government might end up changing that clause, might end up expiring. The opposition might turn it into a wedge issue in the election if Saskatchewaners ultimately disagree with the government's position on this. I think that what it does is it signals, using both at the same time, signals to the judiciary, your words, your final decision on this matter require some acknowledgement that we also are responsible for some of these realities, and that indeed the government has the court has an advantage, a comparative advantage in understanding how its own precedent relates to these questions. The legislature has an advantage in understanding how whatever view of rights comes out of this will relate to the realities of the policy on the ground, the funds available for alternative schemes of schooling that fit the charter rights. So that's mine.
Okay. Jason, do you want to reply to anything in Jeff's comment there?
Only just briefly. I mean, I'm sympathetic to the kernel of the principle underlying your argument in terms of the legislature's role, but as a more facts on the ground procedural matter, the government would be part of the appeal. The government would be able to make its case to the Court of Appeal. The government doesn't need to invoke Section 33 in order to let the courts know that the court has to reckon with the government's position and the government's interpretation. To me, I think Professor Norman makes an excellent point. A good faith, reasoned, deliberative exercise of Section 33, if the government decides, which it doesn't have to pursue an appeal, really should follow the appeal. We should let the judicial process, given that they're the ones who've decided to invoke it, they should allow it to play out.
Okay, thank you. My next question will go in the first instance to Jason, and then Jeff will have a chance if he wants to add anything. And my question is it fictitious to say that there's no destabilizing effect from the Good Spirits School Division case simply because there's a one-year stay when parents and children make decisions on a longer-term basis about schooling and might make a decision on whether to start at a particular school based on assumptions around whether they'll be able to stay at that school or not? And does that undermine any of your argument on the idea that it would be just okay to wait on using the notwithstanding clause?
I don't think it does, and here's why. In the first instance, the stay was for a year. There's no reason why the government couldn't come back to the court and ask for an extension of the stay, particularly if the government was putting in place a deliberative process to decide on what its policy is going to be, and did so in a public way so that there could be a discussion, a full-throated discussion about the religious rights at stake, along with the funding issues, along with issues of rural depopulation. So there's nothing fixed in stone about that one-year stay issued by the court. The government could ask for an extension, but also, one of our own professors in the House has made this argument in print, Professor Birmingham, but one use, a very surgical and precise use of Section 33 can be just to buy more time in order to deliberate and formulate policy. And I really don't think, I agree with Professor Birmingham, that doesn't raise any controversial issues with respect to its use. But simply to say that there's a crisis following a judicial decision that's been stayed, that to me would need more in order to be convincing argument.
Thank you. Jeff, do you want to say anything by way of reply to that?
There's a separate argument from the one I've elaborated here today, made by someone on the dais, in a piece that's available on SSRN, I think, and forthcoming in a book, that there's a procedural use of Section 33, that it can be used to simply buy the government more time. In the Carter decision, I believe Justice Brown in the oral argument suggested that the government could give itself an extension. It was the Attorney General was asking for a 6-month extension. The court gave him 4 to respond to the Carter decision. And Justice Brown said, why don't you give yourselves an extension? A 5-year one, you can get more time. So I'm not sure what I make of that. I think that certainly is a very distinctive use from the kind that I've justified in my theory. It's not necessarily incompatible with it, though.
Okay, thank you. So this question will be to both of you. to go in one order or the other, so I'll invite Jeff to speak first and then Jason, but I'd invite you each to answer it as opposed to trying to respond to each other. And the question is, what one argument on the other side of the debate would you find most plausible as something that could convince you in some circumstance to change your mind?
I think that we've already discussed it, unfortunately, the idea that the government is not thinking about, if there comes to be no evidence that the government is thinking that there might be a rights issue, alternative understanding of charter rights at stake here, and they are just overriding the rights because they don't agree with the policy outcome. If there is no deliberation, then there is no chance of the construction. There's no chance of this establishing an alternative understanding of charter rights. And I find that I'm convinced that that objection to the use of the clause is consistent with my thinking about the conditions for its legitimate use.
Okay, thank you. Jason?
It's a good question. I think that we agree on the productive role that the legislature can play in defining rights, enhancing rights. I really think our really only point of disagreement is likely on the facts of this particular case. So Jeff's argument that the invocation of Section 33 sends a very strong message to the court about its role is an excellent point. And if it had been done consistent with the deliberative way in which you understand Section 33 to derive its authorization, then it would be a really great argument. The fact that it's been done in a way basically absent any reasoning at all undermines that, but the signaling, I think, is a really good point.
Okay, thank you. So in the audience, we have people who've argued for procedural uses of the notwithstanding clause to get time extensions. We have people in the audience that have argued, I think, against the notwithstanding clause ever being used, and so a more radical position than Jason's. And we have people that might write an exam about the notwithstanding clause. So there may be all kinds of questions, and I'd like to give the opportunity, if there are audience questions at this point, to challenge the debaters on some point, or to pursue some aspect of the notwithstanding clause that you find of interest. So are there audience questions that anyone wishes to put? We can't take a lot, but if there are some, this is the chance.
Tito.
This is a question for both of you. Just to kind of clarify and maybe further inform this one out. I would just, the question is, when you're talking about, because you're supposed to agree on the fact that they need to have more reasons disclosed to everybody, not just implement or invoke Section 33. Now, for the practical use of those reasons, is it more of a, for essentially the more political reason, like, now I know your reasons, I'm not going to vote for you next time, or is it more of a, essentially the beginning to almost an overriding clause, to the overriding clause, I think, for the judiciary?
You go first.
Okay. In my conception of that, it's important to understand that the Supreme Court of Canada informed, basically affirmed, and I think wrongly, and I think, along with Peter Russell on this point, that it's really just a formal exercise, and you can read Professor Newman's treatise on constitutional law, and from the 1L perspective, it's important to understand that the justification that I am advocating for doesn't have anything to do with its legal use. However, I think for it to be politically legitimate, the whole basis of Jeff's argument is that legislatures are able to do this. So to be able to have that power, they ought to exercise it. They have to exercise it in order to legitimate it. And then I think you're dead on when you say that it'll help facilitate the one accountability measure, and it's a debatable one, and we should have a discussion about this, but the one accountability measure is the public, right? So without that reasoned deliberation, what is the public to do at the expiry of the notwithstanding period? If it just has stability and school choice to go on, that's not much. So in order for the public democratic accountability function of Section 33 to work as it's designed to work, there has to be reasoned deliberation.
Okay, thank you. Jeff?
I just echo that and say it's not about, it's more, our arguments are more about the political justification of its use. I think my argument in particular cautions legislatures not to think about putting a notwithstanding provision in to a statute with the expectation that then that will just be reaffirmed forever. Its legal expiration points towards the fact that eventually the understanding of rights that goes into that statute is going to be subject to some kind of judicial review. And the court, so it sends a strong signal to the court whenever a court gets to look at it, or if a court ever does look at it, that there's been democratic disagreement with the court on this issue. But it doesn't mean that the legal status of those provisions and their expiration and their requisite reaffirmation means that the legislature can't just be considering its statute as the last word, like the way a statute in the UK. Well, the Human Rights Act has changed, but probably can expect it to happen in its rights statutes. But that's a whole other story.
Okay, thank you. We have a question from Professor Banerjee from the Department of Political Studies.
First of all, thank you to both sides of the debate for the very compelling arguments and really drawing out the nuances of how complicated these sorts of decisions are. I sort of have a question which sort of I think leads on the last question which was asked about the question of political justification, and sort of trying to ask whether maybe the picture needs to be blown up even larger, in the sense that perhaps the process of political justification, which comes up in this case, not only includes expecting the government to present more of a articulated account of the reasons for invoking 33, perhaps appealing to the large percentage of non-Catholic students who are dependent upon the Catholic schooling system, or laying out the arguments perhaps which you've gone into more explicitly. But maybe the largest structure of political justification in fact includes the ballot box as well. Because, I mean, after all, does not the larger structure of political democracy envision, in fact, the accountability of government to be held responsible for not having provided those reasons, such that the expiration within 5 years also anticipates the possibility of another government being in power, which may in fact be able and be willing to take on the political questions much more directly in political discourse.
And so I think that's right. That look, we've changed our constitution from in 1982. We changed our constitution from one where legislatures were supreme, can do anything within the strictures of federalism, basically, to one where we have courts deciding issues of great social importance according to the legal doctrines that they develop. Our culture, our political culture, our legal culture has really done an amazing job, I think, of developing this way for the courts to think about what our rights mean as they relate to these political issues. But our political culture hasn't really absorbed the gravity of having courts involved in these questions and how to deal with them in a way that respects the rule of law, but also doesn't just defer to courts, but also involves some of those questions back and plugs them back into the democratic process. So maybe my view is that it's possible that these pre-enactment charter statements requirements that are going on might be some way of signaling to the voters that this is, and to the opposition, let's say, even that these issues are up for debate, and that discussing them and putting them back into the political arena it doesn't necessarily threaten the rule of law. It might actually help reinforce its legitimacy.
Can you just make a quick comment? Yeah. I really appreciate the question. I think the other aspect of it, though, is that we have to, as a kind of a limit on the accountability measure of the 5-year expiry, is the sort of either the myth, or if that's too strong, the practical elusivity of single issue voters. There are only some voters in any given election for which the legislative enactment subject to Section 33 is the issue. So simply saying that the ballot box provides a measure of accountability, it might in some cases, but it may well not in a great many cases for most voters. And that's a limit on the accountability feature of Section 33 that I wish more Section 33 advocates would discuss and consider. It's a great question.
Okay, thank you. Are there other audience questions on this? So, Professor Luther.
I wanted to ask about, recently in the criminal sphere, we've seen criticism of governments for tweeting after verdicts. Without trying to get us into that field, isn't the invocation of 33 by the Saskatchewan government here subject to exactly the same criticisms, that they're trying to interfere with the appellate process, and that they should just lay off until the Supreme Court has a chance to decide this question?
Can I ask? I think the government's interference in the administration of criminal justice is distinct from the government's interference in determining what our rights mean in the abstract as they relate to the statutes the government's enacted. I think that those are distinctive things, and that Section 33 relates to one and not the other. But then maybe that's a facetious answer. I think that there's something. Look, I think there is something to what you're saying, that we have to be careful with how the government involves itself and relates to courts. It should not be calling courts enemies of the people the way that the British tabloids did in the wake of the Miller decision, the EU Brexit decision in the UK. We have to be careful to avoid that kind of public deliberation and politicization over charter rights. But I do think it's distinctive from the direct intervention. I think it's objectionable for the Prime Minister or the Minister of Justice to be tweeting about an individual case decided that is the traditional purview and sovereign purview of the judiciary. The case of litigants in a particular case and circumstance. Please.
I would just follow with that. Where I disagree with your response is that this isn't just about elaborating the meaning of rights in the abstract. We would have them applied to a very particular set of facts and a context which hasn't been, I would argue, and to be fair, I don't think that the context is fully elaborated or fleshed out in the trial decision, and nor has it been fleshed out in the year or so that has transpired since the government said it was going to invoke Section 33. What I think in this particular case is that, and maybe I'm overreaching a little bit when I say this, but I'm trying to be provocative. I think the Section 33 supporters club, of which both of you are very articulate members, have seized upon this particular use because it very conveniently gets rid of the destitute argument. Right? It hasn't fallen into disuse. It's been used. Okay, so that argument is off the table. That's great. But the problem is that in attaching, Section 33 and its legitimacy to this invocation, it risks, I think, your underlying project, which is showing what the potential, the democratic potential and rights-enhancing potential of Section 33 could be, because I think you just have to admit that this is a ham-handed invocation of Section 33. It's an immediate response through a press release. A year goes by, oh, we're appealing, but we're keeping Section 33 as well. It's not what the framers had in mind. It's not reasoned. It's not deliberative. It's not cautious.
Okay, thank you.
If I understand your argument correctly, you're both saying that the government should have appealed and then used the notwithstanding clause if they had lost. But isn't that I mean, aren't they being more honest to say beforehand what they've said?
I can answer that. Or if you want.
I'm with you.
Okay, so I don't agree with that, and that isn't my argument. My argument would be, and I think your argument should be, that, with all due respect, I'm new to the Section 33 club. I don't know what the rules are.
There are no rules.
The government, in my view, should have said, following the appeal, something reasoned in government, like, this is not the decision we were expecting, we're gonna take some time and study it. That would be number one. Then number two, actually do that. Then number three, that it had a legal argument, appeal. Then it's not simply that, or it shouldn't ought to be simply that, well, we've got 33 in the background, we'll use that if we have to. I think consistent with Jeff's argument, at its highest, which I'm quite sympathetic to, is then the government, in good faith, would engage with the judicial process of the Court of Appeal, and then it would read and consider at its highest the reasons offered by the Court of Appeal. And then if it genuinely had a disagreement, if it genuinely disagreed with the definition of the rights at stake and the way they're to be balanced and limited in a particular public policy context in Saskatchewan, then by all means, if the Supreme Court of Canada isn't willing to take the case, invoke Section 33. But not just hanging in the background. The way the government has done it now is completely ham-handed. To say to the court, we're appealing, but you know what? We're also invoking Section 33, so it doesn't make any sense.
I think it's half-handed. Half-handed. I think that it's legitimate for the court. I think you were right that it's legitimate for the legislature to say, look, and to assure parents, your kids are not. We disagree with this conception of rights. We disagree with this reading of the Charter's relationship with the Constitution Act. We will not. We will stand up for you and your kids' right to go to school and your school's rights, as Premier Wall said. But I think then with Jason that's sending out a press release right away, just saying we're going to use it. Don't worry.
Excuse me. I realize this is
It's sad. I hope it's not the Premier calling.
I hope it is.
I would say that Jason has a point that some study of what the reasoning of the legislature will be for invoking the clause is necessary to have this kind of constructive use. I disagree, though, that they need to choose one or the other. These parents are going to be thinking about what, like as Dwight brought up, these parents are going to be thinking about where their kids are going to be going to school, kids are going into a set of years. They're going to be completely distraught about the idea that they might not have these options going forward into the future. And so the Premier believes, and the government believes, that there's an alternative conception of rights that can assuage the worries of those voters. They can come out with that appeal. They can come out with that use of the notwithstanding clause and appeal it at the same time, signaling to the courts, we mean business, and I think that's maybe it's a bad litigation strategy. I don't know enough about that. Maybe that's your real objection is they'll lose because they do that.
It's not just that. It's just that you can otherwise. There are two different uses of Section 33 at play here in this argument. If it wasn't possible to continue to stay the ruling pending appeal, then a surgical use of Section 33 to say, look, there is a stability issue here. We need to preserve the status quo while the courts figure this out. I don't think anybody would disagree with that. But that's not the way the government has invoked this. The government has invoked it under the cloak of a substantive disagreement that it's failed to elaborate or even facilitate a discussion on. So it's mixing two very different uses of Section 33.
Okay, so we have time for one student question, and then we'll have a question from Professor Smith, and brief replies, and then we'll go to the closing statements. Go ahead.
So on a global scale, thinking more globally, and building on your proposition that perhaps this was maybe a little hasty or a little heavy-handed, and that it might, the reasoning behind invoking the clause might not have been because of the substantial disagreement. What does this mean for provinces across Canada, and what does this mean for further invocation of Section 33? Has it created even more of a stigma on invoking Section 33, or has it potentially opened the floodgates for invoking Section 33 whenever you potentially just need more time, or so what do we see globally as a possible outcome of this decision?
It's a great question. I don't know that we know yet. I think folks who, and there are a lot of smart folks, and two of them are sitting up here at the table, think that this was a good use of Section 33. So I think they'll seize upon it as evidence that Section 33 is alive and well and can play an important coordinate role in the interpretation of rights. I think for those who think Section 33 ought to be eliminated, this won't change their mind. And then I think, my own position, which I think is somewhere in between those, is simply that this is an invocation specific to its facts, doesn't really have implications for the use of Section 33 by other governments, and that really comes down to the process by which it's invoked.
So I agree with Jason that the future is unclear for what this means. Although I would say that however ham-fisted this use is, it is a great leap forward from the use of the clause was put to by Quebec in the wake of patriation. Quebec used the notwithstanding clause to apply the notwithstanding clause to all of its laws that they could apply to in protest of the patriation of the Constitution without their signature. That, of course, that use expired and led to its own series of its own political drama within the province of Quebec. But this use is much more in line with what the Western figures who are responsible for it saw, and I think it bodes well for the use of the clause in a more surgical, constructive way, for which it was intended by the Western provinces as the price for actually changing our constitutional order in this way.
Okay, last question.
Thanks, Dwight. Jason, I'm curious about this idea you have about that the government owes a duty to enter into good faith discussion with the court, right? Governments don't owe anything to the courts. They owe things to their citizens, right? And their citizens seem to be saying they have a policy, the citizens seem to like it. Why is it that the government owes some sort of duty to the court to enter into a discussion about rights when it's the rights of the people in the Prairie School Division who have questions and not the courts themselves? I'm just curious if you can elaborate on that.
Yeah, sure. I don't think that's, so with great respect, that's not my contention, that the government has any duty to enter into a good faith discussion, although I presume it will litigate in good faith. My point simply was, in order to vindicate the justification for Section 33, which is that legislatures will engage in this reasoned public deliberation, I don't think that is consistent with simply invoking the Section 33 override with an absolute paucity of substantive reasons for doing so, or really a meaningful deliberative process. Then basically doing nothing. Then saying, oh, we're going to appeal as well and invoke Section 33. I don't see that there's a duty there, and I'm not saying that the government is violating some sort of procedural rule. I think as a strategy, it's very poor. I don't think you ever convince anyone that you're going to be able to convince them that your side is right when you basically hold a trump card in your other hand. Just as a matter of human psychology as a litigator.
They always have that.
That's poor strategy, but I think the worst, the fatal part of it is it really fails to vindicate the very normative reasons justifying the presence of Section 33 in the first place, to me. They just don't go hand in hand and they're inconsistent. But it's not the violation of any sort of positive duty. So thanks for allowing me to clarify that.
I'm not sure about it. It's wisdom as a strategy. It seems to me that a great deal depends on the norm that courts come to expect in future uses. So do the courts expect that if they decide the wrong way, then it is a trump card, they're going to get whacked anyways? Or do they think that if they compromise and come up with a distinctive kind of decision that tracks some of the government's concerns and maybe some of the things the government has said about it. Hopefully the government has said something constructive about what rights mean in the situation, what they think about that. That maybe the trump card will influence them to share their interpretive role a little more. Otherwise face having their decision be nullified the way that the legislatures in many circumstances face their statutes being nullified.
Okay, thank you. And thank you to the audience for your questions. I don't know anything about where Jason starts talking about the rules of the Section 33 Club. I don't know anything about that. But I do know that one of the rules of the Runnymede Society is people are free to engage in debate and discussion that can go on beyond this room. I'm sure the speakers would be happy to chat with anyone after as well, if there are further questions and they're not too tired. But we will give them a chance now for their closing statements. We're going to give first a chance to Jason and then to Jeff if they want to offer any last remarks. And they'll each have up to 4 minutes to do that, but they may wrap that up shorter if they wish.
I don't know if I have anything more to say. I guess I would just, the thought that I want to leave folks with is simply that I suppose in reading through the background on Section 33, I think it's important that we understand and look at the comparative competence of legislatures and courts with clear eyes. So, chatting with a colleague about this talk last week, sometimes in the defenses, the scholarly defenses of deliberative democracy and reason, it gets lost of what's actually going on in our legislatures and in Parliament these days, and it doesn't necessarily resemble the textbook ideal of solemn deliberation and engagement with ideas. But rather than sound a cynical note in conclusion, because I fully agree with the defenders of Section 33 that courts sometimes get it wrong too, and that individual justices are subject to a wide range of heuristic biases and sometimes fail to grapple fully or adequately with either the meaning of rights at stake or where the rubber hits the road in terms of competing policy interests. I'm actually going to steal what I think is the best point that arises out of Jeff's argument and Dwight's argument as well, which I've had the good fortune to read in advance, which is that Section 33, if used properly, can play a really constructive role. I don't think, with great respect to these two gentlemen, that it's been used properly or even close to properly in the case at hand, but that doesn't mean that it can't be. And for the reasons that they provide in their work, I think it could provide a spur, both to the courts, but also the legislatures, about what's really at stake and what their real role and responsibilities are. And for that, I think that this could have that kind of potential, and if it did, it would be worthwhile. Okay, thank you.
Jeff, last thoughts on which to close?
So Americans have had a lot of time to struggle with judicial review and the power of their courts. There's been many different eras where the courts have had varying degrees of power over different kinds of questions. In the early 20th century, the 1912 presidential election was about the courts. It was Teddy Roosevelt proposing, running as a progressive party, for the Progressive Party, proposing that there should be popular votes on Supreme Court decisions because the court had been systematically striking down any kind of legislation, many kinds of, hundreds of statutes in the states and Congress that Congress had passed, just trying to create better working conditions for people, minimizing their work, minimizing the amount of hours they could be forced to work. And Canada hasn't had this struggle. Canada hasn't had this history of judicial review. We've had this way of organizing our ways of resolving these significant rights issues only since '82. And we have an old tradition, a much older tradition, of being suspicious of our parliamentarians and knowing that there's nonsense that goes on there and voting accordingly. we don't have that kind of tradition, we don't have that kind of awareness or that political culture that Professor Banerjee was talking about, where we go to the ballot box thinking about what our courts are doing. And that needs to change. I think that we should be suspicious of our legislatures and hold them to account in terms of the responsibility they have for enacting statutes that respect charter rights and enact statutes that create constructions of charter rights that we agree with and that we think are valuable. But I think we should hold courts up to suspicion. And I guess I'm just echoing what Jason's saying again. But I think that the true promise of Section 33 is in realizing some kind of balance in our political culture where we're equally suspicious of our courts and our legislatures. That's it.
Thank you. It's a very Canadian debate where the debaters can agree on some things, but I hope that you'll join me in thanking both of them for some initiatives. As I say, I'm sure they're open to chatting further. If you want to talk to Alex,